So
표준
we
필수
are going to
특허와
start the last
브랜드를
session
진행하고
for
있습니다.
this conference.
특허법원
The topic
김동규
is Standard
고등법원
Essential Patent
판사님께서
and Friend.
좌장으로 본
Mr. Kim
세션을
Dong-gyu,
이끌어
the judge
주시겠습니다.
from
큰 박수
the
부탁드리겠습니다.
Patent Court of Korea, will be the moderator. Please welcome him with a big round of applause.
안녕하십니까?
Good morning, ladies
벌써
and gentlemen.
이번 컨퍼런스의 마지막 세션이
It's
되었습니다.
the second day of the
저는 방금
conference, and we're
소개받은
going to have the last
대한민국
session.
특허법원의 김동규
I am
판사입니다.
Kim Dong-gyu, the judge from
먼저
Patent Court
이번
of
세션에서
Korea. First of all,
발표해
I
주신
would like
분들을
to introduce the
소개하겠습니다.
speakers
큰
and
박수로
panels for
맞이해
the
주시면
session. Please welcome
감사하겠습니다.
them with a big round of
먼저
applause.
영국의
First of all,
알렉산더
we have
판사님,
Judge Daniel Alexander from the
다음
UK,
미국의 벤시 뱅고 판사님,
Judge Bensi Benko from the
미국의
US,
콘트레라스
Judge
교수님,
Professor Contreras from the
중국의
US,
추이 판사님,
Judge Chui from China,
벨기에의 그라나타
Judge
판사님,
Granata from Belgium,
현장에 계신 한국의 김기수
and
판사님,
Judge Kim Gi-soo from Korea, who is here with us on site.
다음 일본의
Judge
쿠마가이 판사님,
Kumagai from Japan,
독일의
Judge
샤흐트 판사님,
Schaut from
마지막으로
Germany,
현장에 참여하신 한국의
and
우성엽 고법 판사님이십니다.
Judge Woo Sung-yeop from Korea.
이처럼 각국의
As
저명하신
such,
판사님들과
we have
교수님을
invited
패널로 모시고
world-renowned
이번
judges
세션을
and
진행하게 된
professors
것을
as
큰
panels,
영광으로
and
생각합니다.
I am honored to
이번
be
세션에
with them in the
참석하시는
session.
외국
All
발표자들은
the
모두
foreign
온라인
speakers
실시간으로 참여해
are here
주셨습니다.
with us online
바쁘신
on a
중에도
real-time
이번
basis.
세션에 참여해 주신
I would like to
발표자분들,
thank
특히
the
현지
speakers,
시간으로 새벽
especially
2시임에도 이번 세션에 참여해
Judge
주신 영국의
Alexander
알렉산더
from
판사님,
the UK,
독일의 샤우트 판사님,
Judge Schaut
벨기에의
from
그라나타
Germany,
판사님께 깊이
Judge Granata
감사드립니다.
from Belgium for
이번
being with
세션에서는
us here today,
표준 필수
although
특허와
it's
트렌드 활약이라는
2
주제에
a.m.
대하여
in your own country.
발표자들이 탁월한
In the
고견을 듣고자
session,
합니다.
we will talk about
이번
standard
세션의
essential
주제에
patent
대해서
and friend commitment.
발표자들께서 사전에
In the
자세한
session,
답변을
the
보내주셨고 그
speakers and
내용은
panels sent
레퍼런스 북에
us
정리되어
prior
있으므로
answers,
이를
which
참고해
are
주시기
all
바랍니다.
summarized in
다만
the reference book,
이번
so
세션에
please refer to
참여하시는
them
발표자들도
for more
많고
information.
논의할 세부 주제도
And we
많기
have
때문에
many speakers for the session, and we have
충분한
many
시간을
detailed
드리지 못하는
topics to
점에
talk
대해서
about.
미리
So I'd
양해를
like to ask
구하겠습니다.
you to understand that we are
발표자들께서는
not giving you
모쪼록
enough
주어진
time for
시간 내에
making comments.
답변을
I'd like to
맞춰주시면
ask all the
감사하겠습니다.
panels to finish your
발표자들의
answer
발표를 모두
in
마친 후
time.
시간이
After
허락하는 범위 내에서
we finish all the
질문을 받도록 하겠습니다.
presentations and comments, we will take
시간
questions
관계상
from the
바로
floor.
첫 번째
Due to
소주제부터
time
시작하겠습니다.
constraint, let me start with the first
첫
topic.
번째 소주제는 표준
First
필수
topic
특허와
is
트렌드 확약의 법적
the
성격입니다.
legal nature of standard essential
오시전
patent
첫 번째
and
질문은
friend commitment.
트렌드 확약의 법적 성격에 관한
The
것입니다.
common
표준 필수 특허에 관한 분쟁이 공통
denominator in
공모는
disputes
트렌드
regarding
확약의
SEPs
법적 의미를
is often
밝히는
the
것입니다.
meaning and interpretation of
트렌드
friend
확약의
commitment.
법적 성격에
So would
대한
you please give
자국의
a brief
논의를
outline of the
간략하게
discussions
소개해
taking
주시고
place in your
관련된
own
사례가
country
있다면
regarding
함께
the
소개해
legal
주시면
nature of friend
감사하겠습니다.
commitment on
답변은
any related
3분 이내로
cases as
해주시기
well?
바랍니다.
We would appreciate very
먼저
much if you respond within
미국의
3
콘트레라
minutes.
교수님 답변
Professor
부탁드리겠습니다.
Contreras, would you first answer this question?
Yes, I would be delighted to. Thank you very much for inviting me to be part of this very distinguished panel and talking about this topic. Friend commitments are in the United States and around the world really created through the voluntary adherence of members of a standards development organization to the policies of that standards development organization. One of the policies of these organizations is often to license patents on fair, reasonable, and non-discriminatory terms, or FRAND terms. However, there is a broad range of standards organizations operating in the world, quite a few different methods of adhering to their policies and making these commitments. Some have agreements that must be signed. Some have policies that are simply part of the organization's formational documents. Some commitments are made in purely voluntary statements. So it is difficult to generalize about the legal character of these commitments. However, for the sake of simplicity, I will talk about these as contractual commitments. This is mostly because some of the more heavily litigated SDO policies around FRAND have been found to impose contractual commitments on their participants, going back to the US cases Apple versus Motorola and Microsoft versus Motorola. So if we take for granted that an SDO policy imposes a contractual obligation on participants, then we look at what that commitment requires. The details, of course, are in the policy. However, not all policies are very long or very clear. So we find two general categories of obligations. Obligations around the process of negotiating a FRAND license, and obligations around the content of those commitments. The process obligations generally require the parties to negotiate in good faith, to continue negotiations for some period of time, possibly to refrain from seeking injunctive relief during that negotiation, and possibly to submit disputes to some sort of adjudication. The content obligations that exist relate to how high the royalty rates must be and what the other reasonable terms are in the FRAND license. Usually there is some combination of this process and content obligations. There are examples in numerous US cases of this. TCL versus Ericsson is one recent one, in which Ericsson, the SEP holder, was found to have negotiated in good faith, and its conduct did not violate the FRAND obligation of the standards organization. However, the rates that it proposed did violate the FRAND obligation. They were above the FRAND obligation. And so you can have both process and content in tension. That, I think, is about all the time that I have. There are certainly more details on this very interesting topic in the written response to the questions.
예. 콘트레라 교수님 답변 감사합니다.
Thank you very much,
다음
Professor
독일의
Contreras.
샤우트
Let's
판사님
listen from
답변
Judge
부탁드리겠습니다.
Schaut from Germany.
Thank you very much. Thank you very much for having me here at this session 5. Very interesting question. From a German standpoint, it is a very interesting question because in Germany, this question is not, at least at the moment, not in the middle of our discussion. However, we see that it is a problem how to deal with FRAND commitment. I would say there are two opinions how to assess the legal nature of FRAND commitment. The one would be it has only a declaratory character, so it's not binding at all. The other solution would be, yes, it might have a legally binding character, so it's a contractual sort of thing. The thing is, in Germany, if we have a standard essential patent, we usually solve the problem with, or the case, applying the EU antitrust law and applying the cases of the federal court of the European Union. And one problem which arises when we come to the question, does a FRAND commitment has a legally binding character? We have to assess the country to which these commitment shall govern. So the problem would be that in a lot of declarations, it is not said which law of which country does govern this commitment. And so it might be that in a case we would have to find out which law of which country has to be applied to see whether it is in what kind of contractual commitment is this FRANT commitment. So there are some declarations, I think it's ETSI, which says that the declaration has to assess under French law. There are other organizations which does not say at all which law has to be applied, which gives the judge in Germany some uncertainty, which we do not like. I would say that's so far from me. To make it short, I would say FRANT commitment, the nature, it is not in the middle of the discussion in Germany. Why not? Because if we have a standard essential patent, we apply the EU antitrust law. Thank you.
샤우트 판사님 답변 감사합니다.
Thank you very much for your
벨기에
answer.
그라나타
Next,
판사님
we'd like to listen
부탁드리겠습니다.
from Judge Granata from Belgium. Judge Granata from Belgium, would you answer the question?
I don't know if it's my turn to speak because I don't hear, I don't have a good connection, I guess. But anyhow, thank you for having me. First of all, I have to address the issue that in Belgium there are only some pending cases regarding France. So my answers are based on my personal experience, examination of foreign decisions, but also being a member of the EU Expert Commission Group on France, which will issue, I guess, within the next weeks, its final report, in which you will find diverse structural reforms regarding the process of transparency, of information negotiation process and procedure. Regarding the legal nature of SEP's France, I can refer also what Professor Contreras and Mr. Schacht already pointed out, that an important element is, of course, a law to be applied to assess this issue. The commitment is to be found in the contract, the IPR policy between the SAP holder and the SDO. And this contract normally stipulates applicable law. As already mentioned, by, for example, by Mr. Schacht for ETSI, this is French law. And if you would go into
그라나타 판사님 답변 감사합니다.
contract for the commitment for the benefit of third parties. However, the contract states an obligation in the form of a benefit towards him as a third party. The third party can make use of this contractual obligation, this FRANT commitment. There are some conditions which have to be met. I won't go into these conditions in detail. You will find them in the questionnaire. But it is important. I really want to stress that we have to go, the first step we have to take is, of course, the applicable law issue. And we have to go into the applicable law to examine whether or not which law applies to this commitment. And I think the Lex Forum normally is not that suitable. And we should look into the IPR policy of the contract between the SAP holder and the SDO. Thank you.
예, 그라나타 판사님 답변 감사합니다.
Thank you for your
다음
answer.
일본의
Next,
쿠마가이
we'd like to
판사님
listen
답변
from
부탁드리겠습니다.
Judge Kumagata from Japan.
안녕하세요, everyone. It's my honor and pleasure to participate in this great event. So let me briefly introduce the Japanese discussion on this matter. Yes, and in Samsung versus Apple case, rendered by the Grand Panel of IP High Court in 2014, by interpreting contents of the ETSI's IPR policy and French law applicable to that policy, the IP High Court concluded that the FRANT declaration in the case should not be considered as an offer for license agreement. The IP High Court further held that shareholder who committed front declaration undertakes an obligation to have a good faith negotiation with willing licensees. However, I would like to stress that these court findings in the Samsung versus Apple case was made on a case-by-case basis. The other panelists already pointed out the assessment of the legal nature of fund commitment, I think that should be made closely examining on the contents of the commitment and applicable law. So that's all. That is end of my answer. Thank you.
예, 일본의 쿠마가이 판사님.
Thank you,
답변
Judge
감사합니다.
Kumagata, for your answer.
다음은
Next,
중국의 추이
we'd like to
판사님.
listen from Judge Chui from China.
예, 답변 부탁드리겠습니다.
Okay, thank you very much. I feel very honored to attend to this conference. The two main views of the legal nature of friend in our country are to regard it as a unilateral legal act or as an invitation for offer. I think both of two views are reasonable and effective. The main problem of the view of unilateral legal act is that a unilateral legal act is generally a clear declaration of will, such as gift, waiver, and only set a burden on the doer himself. But a friend does not contain concrete content. So
예. 추이 판사님이 지금 연결이 잘 안 되는 것 같습니다. 우선
Seems like there are technical issues with the connection, so Judge Kisuki, would you please first answer the question?
김기수 판사님 답변 부탁드리겠습니다.
안녕하세요.
Good morning, everyone.
김기수
I'm
재판연구관입니다.
Kim Gi-soo from
먼저 이렇게
Supreme
귀한
Court.
자리에서 제
It is
의견을
my
말씀드릴
honor
수 있는 기회를
to
주셔서
present
감사드립니다.
and answer this question in this
모두가 잘
conference.
알다시피
As you may well know,
표준화는 상호 호환성 증가 등 시장의 효율성을 증대시키는 장점이
standardization
있지만
has many advantages
표준으로
in
선정된 기술
increasing
특허를 보유한
compatibility,
사업자에게는
but SAP
일반적인
holders
지식재산권이 부여하는 정도를 훨씬
may
상회하는
have some
시장
disadvantages,
지배력이
and it
부여됩니다.
also SAP
이와
holders
같은
may also
강력한 시장
have a
지배력은 남용되기가 매우 쉽습니다.
position that will have
표준 기술을
market
이용하고자 하는
dominance that could
자에게
be well
공정하고
likely
합리적이며 비차별적인
abused.
조건으로 실시권을
So,
허용하겠다는 내용의 브랜드
non-discriminatory
확약은 이와 같은
commitment,
표준
which is
필수
a friend
특허권의
commitment,
남용을 방지하기
is
위한
in the place,
최소한의
in
안전
place,
장치라고 생각합니다.
and it is a safety net to
브랜드
prevent the
확약은
SAP holders from abusing
특허권자의 표준화
its
기구에
position.
대한 의사 표시로 이루어집니다.
It is a
따라서
kind of a
다른
commitment
패널들께서 이미
to
말씀하신 것처럼
license the
브랜드
terms
확약의
of the
법적인 성질이
SAP
무엇인지
to
밝히는
the
것은
implementers of the
기본적으로 표준화
SAP.
기구의 특허
So as many
정책,
people already said
특권자가
before
제출한
me,
브랜드 확약서의 구체적인 내용,
the contents of a
증거법 등을
friend
종합적으로
and
고려해서
governing laws
판단해야
should be
하는
considered
의사
to
표시
determine whether
해석의
there is
문제입니다.
a breach of the friend commitment.
한국에서는
In Korea,
2012년 삼성 애플 사건에서
in the
서울중앙지방법원이
patent litigation between Samsung
삼성전자가
Electronics and
제출한
Apple,
브랜드 확약의
the
의미에 관해 브랜드 조건에 따른 라이센스 계약 체결을 위해 성실하게 협상할 의무를 부담하는 것이라고 판단했습니다. 법원은 브랜드 확약이 제3자를 위한 라이센스 계약의 청약이거나 침해 금지 청구권의 포기에 해당된다는 주장을 받아들이지 않았습니다. 삼성 애플 사건은 브랜드 확약과 금지 청구 가능성에 대한 이 주제에서 보다 상세히 다룰 예정입니다. 2019년 퀄컴의 공정거래법 위반 사건에서 서울고등법원은 퀄컴의 브랜드 확약의 의미에 대해 브랜드 조건에 따라 성실하게 협상하고 라이센스해야 될 의무를 부담하는 것이라고 판시했습니다. 이 사건에서 법원은 퀄컴이 경쟁 모뎀 칩셋 제조사에 라이센스 제공을 거절한 행위를 브랜드 확약에 위반한 행위로 보았습니다. 이 사건에 관해서는 브랜드 확약과 공정거래법 위반에 관한 선 주제에서 보다 상세히 다룰 예정입니다. 감사합니다.
김기수 판사님, 답변 감사합니다. 중국의 추이 판사님, 혹시 답변 준비되셨습니까?
Thank you. Judge Chui, are you ready to answer the question?
Can you hear me?
예, 답변해 주시면 감사하겠습니다.
Sorry about that. The two main views of the legal nature of friend in our country are to regard it as a unilateral legal act or as an invitation for offer. I think both of two views are reasonable and effective. The main problem of the view of unilateral legal act is that a unilateral legal act is generally a clear declaration of will, such as gift, waiver, and only set a burden on the doer himself. The friend does not contain concrete content, and the willing licensee also have obligations in negotiation. The main problem of the view of invitation for offer is that a SCP holder make a friend commitment does not mean he is willing the others to make an offer to him. So the courts tend to avoid directly stating the nature of friend commitment in judgments. And we don't take friend as a contract for the benefit of third parties because China's present contract law only provides that the parties of contract may agree that the debtor shall perform his debt to a third party. But this is not an article about the contract for the benefit of third parties. The third party does not have the right to request performance. Today, I would like to talk about the possibility. China's civil code will come into force next year. According to Article 522 of China's civil code, the parties can agree that a third party may directly request the debtor to perform the debt to him. And if the debtor doesn't, the third party may request the debtor to assume the liability for breach of contract. So some scholars think that since there is legal basis, we can regard friend as a contract for the benefit of third parties. No matter what the legal nature of friend commitment is, the consensus is we should consider both parties' behaviors in lawsuit. Thank you.
추이 판사님 답변 다
Thank you
끝내셨습니까?
very much. Have you finished your answer? Yes.
답변 감사합니다.
Thank you.
Thank you.
영국의 알렉산더 판사님, 혹시 이 점에 이
Judge
질문에 대해서
Alexander,
말씀하실
would you like
사항이
to
있으면
say
말씀해 주시기
something
바랍니다.
about this topic? Would you like to add? Judge Alexander, would you like to say something about this topic?
Thank you very much, and again, it's a great honor to participate in this session. Two very short comments. First, in English law, the approach is similar as a matter of legal theory to that of United States law, namely that the friend commitment is a contractual commitment. Precisely what the content of it is will depend on the nature of the contract and the law by which it is governed. However, the approach that the English courts have taken is that essentially it's a contractual commitment that can be used by an implementer as a defense to patent proceedings in these circumstances, the English court will regard itself as an appropriate forum to determine what the FRAND terms are, and if those terms are offered by the SEP holder and they are refused by the implementer, then the English court will grant an injunction normally in relation to the SEP. So the practical approach that the English court takes is much more similar to that it would take in the context of collective copyright licensing or licensing of a patent under a patent that is declared to be license of right, even though the commitment in question is a contractual one. All of that comes from a long decision of our Supreme Court earlier this year in a case called Unwired Planet, of which I have summarized the details in the notes. And there is considerable developing case law on exactly how the FRAND commitment is to be worked out, which will be done in future case law in coming years.
예, 알렉산더 판사님 답변 감사합니다.
Thank you for your answer, Judge Alexander.
이번 세션은 모든 외국 패널들이 지금 온라인으로
Here,
접속한
all
상태에서
foreign speakers and panels are participating in the session online, so we have some technical glitches. Please understand the situation. And second topic,
이번 두 번째 소주제는
the second topic
표준
is
필수 특허 침해에 대한
the
특허권자의 구제수단을
remedies
먼저
for the infringement of SEP. The first question is,
표준 필수 특허 침해에 대한 구제수단 중
when a third party uses an SEP without a license agreement, the question of what means of relief are available to an SEP holder is a critical issue. Then, can a FRAND-committed SEP holder seek an injunction against an implementer? Please explain any standards or factors to take into consideration when deciding whether or not to grant an injunction sought by an SEP holder. I'd like to ask you to answer the question in 3 minutes. First, Judge Chui from China.
Okay. Some foreign patentees like to file lawsuits of patent infringement in China. One of the reasons is that they think it's very easy to acquire an injunction. That's kind of true, because in our opinion, to seize the act of infringement is the basic liability of the infringer. In SEP infringement lawsuits, because of the FRAND commitment, more factors should be considered, but injunction can also be granted. In the judicial interpretations issued by the Supreme People's Court, the rules are described as if the patentee deliberately breaks FRAND, resulting in the failure to reach a license agreement, and the accused infringer is without apparent fault, the patentee's request for injunction should generally not be supported. In the judgment of Xidian Jietong, which is also called IWNCOM versus Sony, a more detailed explanation was given by Beijing Appeal Court, which is if the implementer doesn't have fault in negotiation, no matter the patentee has fault or not, the request of injunction should not be supported. If the implementer has fault, that depends. In the case that the patentee doesn't have fault, an injunction will be granted. In the case that both parties have fault, we balance the interest of both parties based on their fault to decide whether to grant an injunction. And Guangdong Province High Court's opinion is a little different in its guideline. In their opinion, in the case of no fault of both parties, a reasonable assurance should be submitted by the implementer to avoid the injunction. When judging the fault, we consider the time, the way, the content of negotiation, and the reason of deadlock or break of negotiation. and business practices of existing SEP negotiations are also important references to decide which party has fault. Thank you. That's my answer.
예, 주의 판사님, 충실한 답변 감사합니다.
Thank you very much for your answer.
쿠마가이 판사님,
Judge
일본의
Kumagai
쿠마가이
from
판사님,
Japan.
답변 준비되셨습니까?
Are you ready to answer the question?
예, 답변 부탁드리겠습니다.
Please.
Okay. Yes, sir. In Samsung versus Apple case, the Grand Panel of the IP High Court took the so-called the abuse of right approach on this issue. Under this approach, a stakeholder who committed a fraud declaration is basically prohibited from seeking injunctive relief against the implementer of SEP. In other words, by expressing willingness to enter into a front license agreement, the implementer can evade an injunction. However, if the implementer fails to establish the fact before the court that the implementer is a willing licensee, an injunctive relief can be granted to the stakeholder. The court determines whether the implementer has genuine willingness or not, comprehensively considering various factors appearing in the case. Not only its implementer's actions during the negotiation process, but also the stakeholder's actions are taken into account in deciding whether the injunction against the implementer is permissible or not. I think this comprehensive approach gives a wider discussion to the court. But, however, it can be said at the same time that the ambiguousness of this approach impairs the predictability of the parties. That's the end of my answer. Thank you.
예, 쿠마가이 판사님, 답변 감사합니다.
Thank you very much for your answer. Next,
답변 부탁드리겠습니다.
Judge Usung-yeop.
안녕하세요.
Good morning, ladies and gentlemen. I am Usung-yeop from Patent Court of Korea. First of all, I am very pleased to be with world-renowned judges and experts in this session. I would like to explain about the injunction claim under the Korean patent law. So, Korean Patent Act defines that only infringement of patent rights is the condition for a petition for injunction against patent infringement. So even the SEP holder made friend commitment, he can request an injunction against the implementer. But if it is regarded as abuse of power, then the exercise of claiming the injunction against the patent infringement could be restricted. And there is no precedent ruled by the Korean Supreme Court for whether or not the petition for injunction against patent infringement was permitted. But in the Samsung Apple case, the Seoul Central District Court made a ruling that between willing license and unwilling license, there should be a clear distinction. As for unwilling licensee, there's almost no restriction on the exercise of the injunction for infringement of the patent. And the SEP holder has the duty to negotiate the license in good faith with a willing licensee. And until such negotiation is completed, the SEP holder should not claim the injunction against the patent infringement. And also in this case, the licensee should be the willing licensee. In the Samsung Apple case, There have been several conditions mentioned to determine whether the implementer is an unwilling licensee. The first element is that the defendant should be aware of the existence of standard patent and the defendant's implementation of the patent invention, but use the license without any request or consultation with the patent holder to grant the license. The second condition for unwilling licensee is that if the standard patent value was excessively underestimated, and there's a difference between the defendant's proposal of the initial royalty rate and the normal ordinary royalty rate, and also when the defendant has not proposed any deposit equivalent to the royalty rate. These are the conditions for determining the unwilling licensee. Judge Granada from Belgium, are you ready to answer?
답변 부탁드리겠습니다.
Please.
Yes, I'm ready. I hope you understand me. First of all, I think as an introductory note, I think it's important to note that at least in European Patent Convention, in law, there is no such a thing as a standard essential patent. A patent is a patent. So normally the friend commitment as such does not provide an implementer a right to use an SIP. It states that the holder should commit himself to offer a willing implementer a license on friend terms. If such a license has not been agreed upon, the SAP holder should, in principle, as every patent holder, be entitled to be granted an injunction. Under Belgian law, and I think most laws, you have principles as something as misuse of rights, and that's where the judge can decide that actually the implementer, the SAP holder, is not empowered to use this right because he misused the right throughout the process. It is difficult, without having any specifics on an actual case, to provide the standards, but elements which could play a role, for example, could be unnecessary excessive confidential agreements asked by the SAP holder, not giving sufficient information regarding the SAP and or the portfolio for the implementer to examine the potential infringement and or essentiality, and not providing sufficient information regarding the calculation of an offer or rejection of a counter offer. Should the breach of the friend commitment be considered as a misuse of right, an injunction normally will still be granted but could be made conditional on specific terms. As already mentioned by a speaker before me, the willingness and unwillingness is something which is very important. Again, it's a very factual element, but based on examination of some decisions, maybe as unwilling, for example, could be declining to use ADR to solve the dispute, could be challenging the essentiality or patentability of a proven SAP. Proven should be understood as a factual circumstances where, for example, several other EU courts would
또 통신 장애가 있는 것 같습니다. 예.
Seems like technical glitches are happening again.
답변 끝나셨습니까?
Judge Granada, have you finished your comments?
But I think in the questionnaire you will find the examples.
예. 예, 답변 감사합니다.
Thank you for your answer.
다음 독일의 샤우트 판사님.
Next, Judge Schaut from Germany.
준비되셨나요?
Are you ready to answer the question?
Thank you again.
예.
I had actually 3 comments on this topic. First will be on the injunctive relief itself in Germany. Second will be the application of the injunctive relief in so-called SEP cases. As third comment will be on a recent amendment of the German Patents Act. So first to the injunctive relief. In Germany, it is so-called automatic injunctive relief, which means if the requirements of an injunction are fulfilled, there is no further discussion whether it has to be granted or not. However, also the injunctive relief needs to be proportionate. This is not a written requirement, but an inherent requirement. But currently, the overwhelming opinion of German courts, outlined by our Federal Court of Justice in a decision called Wärmetauscher, you can find it in my written answers. So the opinion is that the situations in which an injunction in German patent law is not proportionate is very, very seldom, and the reasons need to be very, very special to make an exemption from the automatic injunction. So to the second comment on the special situation of SEP cases. In Germany, of course, we will assess when we have an SEP holder suing an implementer. First, we will assess: do we have patent infringement, and is the patent supposed to be valid? I say it is supposed, because, as you may know, in Germany we have a bifurcation. So we as infringement judges, we take a look, but we do not decide whether it's valid or not, the patent. And the third thing we will see in this SEP cases is whether the defendant, the implementer, is a willing licensee, yes or not. It's a very the current discussion here in Germany. We have a judgment from our Federal Court of Justice, and it is highly discussed in Germany. What are the real followings of this discussion? So we will see whether the implementer is a willing licensee. Then we will refuse the claim, and we will. And if he is a willing licensee, we will see whether the SEP holder was doing his obligations according to FRAND, whether he was offering friendly conditions to the implementer. Then I would come to my third comment. As you may know, we have a lot of SEP cases in Germany, and at least the legislator, our government, has seen some need to amend the injunctive relief in Germany. It was also highly disputed. Now it is clear that there will be an amendment of the injunctive relief, which will emphasize the aspect of proportionality within the injunctive relief. So it will say it will actually say the automatic injunction is still the norm, the normal case. But as court, you have to look whether it is in the case. You have to decide whether it is proportionate or not. Please do so, court. Please assess it with a more eager. These are my comments. Thank you very much.
예, 샤우트 판사님 답변 감사합니다.
Thank you, Judge Schaut, for your answer. In the case of Germany,
다른 나라 비해서도 많이 더 강조하는 경향이 있는 것 같습니다.
emphasizing that point. And Judge Alexander, are you ready to answer?
Yes.
예,
thank
답변
you again.
부탁드리겠습니다.
So similarly to other jurisdictions, in the United Kingdom, infringement and validity of a standard essential patent has to be established first of all before you get into considering whether there is a FRAND determination. As in what is proposed to be the German law, in the United Kingdom, patent injunctions are almost automatic. but proportionality is taken into account, more commonly in cases involving, for example, life-saving drugs and so forth, less commonly in other cases. In FRAND cases, a FRAND-committed SEP holder can seek an injunction if an implementer doesn't take a license, which has been determined by the court to be FRAND. And the courts have said that in those circumstances, the implementer is standing before the court with an infringed patent, has the means to obtain a FRAND license, but has refused to take that license, and therefore an injunction will be granted. So far in English law, there has been less focus on the issue of willingness or unwillingness historically of a licensee. So in the leading case in Unwired Planet, neither the SEP holder nor the implementer had made an offer which the court regarded as FRAND. But the court was able to solve that problem by determining for itself what was FRAND. And once that was determined, the implementer had to take that license unless, in order to avoid an injunction. There are, however, a number of issues outstanding similar to those just mentioned by Judge Schacht, relating to the unwillingness of a licensee. There are cases, even currently in the last few weeks, in the English courts, where directions are being made to determine whether a licensee is unwilling if they do not commit in advance to taking a license settled on terms by the English court. Now, the procedure for that is a bit up in the air at the moment. Whether that will happen in that way is at the moment not clear, but there will be some developing case law in that area in the next 6 months.
예, 알렉산더 판사님 답변 감사합니다.
Thank you very much for your answer.
유학생들 같은 경우는
In
달리
the case
취급한다는
of
부분은
UK,
다른 나라에
they
비해 흥미로웠던 것
apply
같습니다.
different regulations to the life-saving drugs.
답변 준비되셨습니까?
And Judge Bensivengo from the U.S., are you ready to
예,
answer?
답변 부탁드리겠습니다.
Yes, and thank you for inviting me to be part of this, and I'm pleased to be here to provide a little gender diversity as well to this panel. The question of injunctive relief for FRAND patent for SEPs is an interesting question. Injunctions in the United States are a matter of equity. So although we talk about these things in terms of contract, in most instances, they are contracts without the necessary material terms where you could simply say you're in breach, here, pay the damages and move on. So when you come in and your obligation under FRAND is to negotiate in good faith, then it does get back, as Judge Alexander said, to the question of, well, are you negotiating in good faith? And that can be part of an equitable determination as to whether there's irreparable harm to the patent holder because they've given up this technology with the expectation people will take a license. And if someone's just refusing to do so and not negotiating at all, I think it will strengthen your position as a patent holder to enjoin them and not let them just be free riders. It becomes more complicated if there are offers on the table, and particularly if it's early on in the context of a preliminary injunction and you have very little information as to what a reasonable licensing fee would be for this particular implementer, and each side is trying to tell you, well, their offer is fair and the other side saying no, then you don't necessarily have unwilling people, you just have a dispute for the court to decide. I think in that context, courts should consider exercising their equitable opportunities and authority to suggest payments made to some escrow account so that the person who wants to implement is meeting their obligation to make a payment, and the final amount would then involve some settling up at the end, either for a refund or for additional payments, but that there's security to the patent holder that they will be paid for this use. Those are ways to sort of work around it, but the court has become very clear here, certainly the Federal Circuit, that we can issue injunctions to SCP holders in the proper equitable circumstances. So that's, I think that's probably my 3 minutes.
예, 답변 감사합니다.
Thank you for your answer.
다음 이번 질문은 영국의 알렉산더 판사님에 대한
Now,
질문입니다.
this question goes to Judge Alexander.
표준 필수 특허 침해가 인정되는
As we
경우에
understand, if
피고에 대해 조건부
SCP
금융명령을 내린 사례가
infringement
있는
is
것으로 알고 있습니다.
recognized, the conditional
이에
injunction
대해
order
좀더
is
자세하게
issued
소개해
that
주시면
actually happened in the UK. Could you introduce
답변은
this
3분 이내로
case
해주시길 바랍니다.
in 3 minutes?
알렉산더 판사님 답변 부탁드리겠습니다.
Judge Alexander.
Yes. So the only case so far that we've had that has gone all the way is a case called Unwired Planet and Huawei and ZTE, which was decided by our Supreme Court earlier this year, and it confirmed the earlier decisions of Mr. Justice Burse and the Court of Appeal that the English court could both settle FRAND terms on a worldwide basis, and if those terms were not taken by the implementer, to grant an injunction on the basis of valid and infringed patents in the portfolio. That has given rise to a number of issues, some of which we'll touch on in the later sessions, as to, well, what is the right approach to FRAND determination and some of the procedural issues, including on confidentiality, which one of the other speakers has mentioned. There is one qualification to this, just for information. We have had 2 cases in the United Kingdom where implementers have said, we will agree to leave the United Kingdom market, and so we are not interested in taking a FRAND license settled by the United Kingdom court. And in those circumstances, the United Kingdom court has said, we can't force an implementer to take a license, so for example, one covering the past. We can only deal with back damages. And the principles on which back damages are to be assessed for a United Kingdom patent are themselves the subject of current dispute in 2 cases, one of which is, I think, this week, possibly going to the Court of Appeal.
예, 알렉산더 판사님 답변 감사합니다.
Thank you for your answer.
이것과 관련해서 말씀드릴 부분이 있습니다.
Regarding this,
부분에는
I'd like to say
경우
that in the case of
조건부
the
금지 청구가
UK,
인정되는 것으로 표시되어 있습니다.
it says conditional injunction is recognized. As you see on the slide, it says conditional injunction is recognized, and he sent us an email that the UK conditional injunction is different from the US, so we actually had to change the mark.
그 이유는 알렉산더 판사님 답변과 같이
As
실시자가
he mentioned,
프렌드 조건에 따르는 실시 계약을 체결을 거부하는 것을 조건으로 해서 금지 명령을 할 수 있다는 취지였기
the
때문에
injunction can be made on the condition that the implementer refuses to sign that license.
일반적인 다른
So
나라의 금지
the
청구와
way
사실상
the
동일하다는 취지로
UK
답변을 주셨습니다.
gives
그래서 그 부분은 참고하시기 바랍니다.
recognizes conditional injunction is different from other countries.
두 번째 소수재 중 이제 손해배상 청구에 관한 부분.
And
이번
the second
질문은
one is
표준
about
필수 특허 침해에 대한
damages.
구제 수단 중 손해배상 청구에 관한 것입니다.
As a remedy
표준 필수
for
특허 침해로 인한 손해배상
the
청구에는
SCP infringement,
손해배상 청구 사건에는
there are
표준
many
필수
issues
특허권
unique
및
to the
표준화로 인한
determination
가치
of the
부분의
amount
배제
of
방안,
damages for
실시로
SCP
과정 문제,
infringement, exclusion of
합리적이면서
value added
비차별적인
from
실시로 선정
standardization,
방안,
and
표준 필수 특허권자의
assessment
팬더
of
확약 위반이
non-discriminatory
손해액
and
수익에 미치는
reasonable
영향,
royalty rates,
무단 실시자에 대한
impact of breach
손해배상의
of
금액
friend
가능성 등
commitment by
특이한 쟁점들이
SCP
있습니다.
holder, in
표준
the
필수 특허
assessment
침해에 대한
damages, and
손해액을
many
산정할 때
others.
특별히
When you
고려하는 요소
assess
및
the amount of
구체적인 손해액
damages
산정
for
범위에 관한
SCP
각국의
infringement,
실무를 소개해 주시면
could you
감사하겠습니다.
introduce factors that are
답변은
specially
3분
considered
이내로 해주시길
and
바랍니다.
specific
먼저
methods in
미국의
3
최이파사님
minutes? Judge Chui
준비되셨으면
from
답변
China.
부탁드리겠습니다.
Yes, I would like to answer the questions of this topic in two parts. The first is how to consider special factors by traditional methods to determine the amount of damages in ICP lawsuits. Because as far as I know, there is only one case in which the court awards damages, and it's by traditional method. Some factors can be considered by traditional method. For example, about the royalty stacking in the judicial interpretation of patent infringement, the Supreme People's Court rules that the profit produced from other rights should be excluded. And if the infringing product is a part of other product, the court should determine the amount of damages based on the value of this part itself and its role in the product's profit. And about unwilling licensee, in the only case of awarding damages, the defendant was regarded as an unwilling implementer, and the court awarded triple of royalties of other licensees. But that's not punitive damages. That's a general provision of China's current patent law, which is reasonable multiple of royalties. And as to the value of SEP, the general view is that its value includes only the inherent value of the patent rights, but not the value added from standardization. Because the patentee's contribution is just the innovation of technology, but not the standardization. Because it's not judicial pricing of royalties, so we can take all these factors into account, just as what we do in other patent infringement lawsuits, and make our discretion. However, the defect is that it's not accurate, it leaves too much room for discretion, and the royalty is still not settled. And the second part of my answer is, beyond infringement lawsuits, there are several methods of calculation in determining royalties. For example, in Huawei versus IDC case, the court used comparable license approach. In Huawei versus Conversant case, the court used top-down approach. And in Huawei versus Samsung case, both of the two approaches are used. So there could also be methods of determining amount of damages. But I think that depends on the plaintiff's assertion. If there is no assertion, no information, no evidence, the only method to determine the amount of damages is the traditional way with special factors taken into account. That's my answer. Thank you.
예, 답변 감사합니다. 중국의
Thank you
경우에
for your answer.
표준 필수 특허 침해에 대한 손해배상에서
Regarding
특별한
SEP infringement
규정이
and
있는
its
것은 일반
damages,
특허법상의
there's no
손해배상
special
규정을 준용하되
rules
주로
in China.
합리적인 실시로 규정을
They
따라
follow
하고
the
증거가 부족한
reasonable
경우에는 법원에서
reasoning
직권으로 증거
and
조사하되
reasonable royalty is
침해자
assessed.
이익 내지는 피해자의 손해액을 고려해서 산정한다는 취지로 말씀 주셨습니다.
So thank you
답변
for
감사합니다.
explaining
다음
about how you
일본의
calculate the
쿠마가이
amount of
판사님
damages.
답변 준비되셨으면
Next, I'd like to
말씀
ask
주시기
Judge Kumagai from Japan.
Yes, thank you. According to the Samsung versus Apple case, and in Japan, a stakeholder is basically able to seek compensation for damages equal to a friend royalty. And in the case where the stakeholder established a fact that the implementer is an unwilling licensee, the stakeholder is able to seek damages exceeding a friend royalty. And on the contrary, if the court evaluates the stakeholders' actions during negotiation process as extremely unfair. The stakeholder is prohibited from seeking compensation for damages, even equal to a friend loyalty. And secondly, and concerning the methodology for assessing the friend loyalty, the IP High Court took so-called top-down approach in Samsung versus Apple case. Please refer to my written answer for the detail of this approach. It is said that based on this approach, the IP High Court determines the loyalty rate of the disputed step for iPhone 4 is 0.0020%, and the loyalty rate for the iPad 2 is 0.0070%. And thirdly, and as for damages and exceeding friend loyalty, theoretically, the stakeholder is entitled to seek a compensation for damages based on Article 102, Paragraph 1 and Paragraph 2. But currently, we have no rulings on this matter. So, and finally, and I'd like to stress that the recent Grand Panel case, which I mentioned in my written answer, might have effect on the determination of friend loyalty during infringement lawsuits in the future case. Thank you.
예, 쿠마가이 판사님 답변 감사합니다.
Thank you for your answer.
다음은 한국의 우성엽
Next,
고판사님께서 답변해
Mr.
주십시오.
우성엽 from Korea.
표준 특허 침해를 원인으로 한 손해배상
In the
청구의
case
쟁점은
of the damages claim for the infringement of standard essential patents, the issue is whether the patent holder can request the implementer to pay damages exceeding the royalty rate under FRAND. Regarding this, we need to see if the defendant is willing
이와 관련된
licensee.
한국에서의 논의를 요약하면
So regarding this, in
윌링
Korea,
라이센스에 해당하는 경우에는
if
피고에
the
대한
defendant
손해배상
is the
청구는
willing
프렌드
licensee,
조건에 따른
then
실시료
the
상당액으로
damages for the
한정된다는 것이
defendant
다수의
will be
견해입니다.
limited to the
반면에
amount
피고가
equivalent to the royalty
무단실시자,
rate
즉
under FRAND.
unwilling 라이센스에 해당하는
If the
경우에는
defendant is unwilling licensee,
서울중앙지방법원의 삼성 애플 사건의 판결에
according to the
따르면
Samsung
피고에 대한
Apple
손해배상
case
청구는 프렌드 조건에 따른 실시료 상당액
decided
외에도
by Seoul Central District
특허권자가
Court,
입은
the
일실이익이나
damages for the
피고가
defendant
침해 행위로 얻은 이익액도 손해액으로서
will
주장할 수
include
있다는
the
입장에 서 있는 것으로 보입니다.
lost
또한
profit of the
실질을
patent
상당해서
holder
중요한 요소인
and the infringer's
비차별성
profit
요건과
from the act of
관련해서는
infringement.
한국에서는
And as for non-discriminatory
비차별성이라는
requirements,
의미가
in
누구에게나
Korea,
동일한 조건과 동일한 실시료율로
non-discriminatory
실시 허락을 해야 한다는 의미는
does not
아닌 것으로
mean that
해석되고
all
있습니다.
licenses should be allowed
비차별성이란
to use the license
실질적으로
under the same
유사한
royalty rate
지위와
under the
상황에
same
있는 실시자들
condition,
사이에서 다른
but it
취급을
means
해서는
that
안 된다는
there
것을
should be no
의미합니다.
discrimination
따라서
in the treatment
설령
among the
여러
licenses
라이센스
with
계약들에서
technically
각각
similar
정해진
status and
실시료율이나 실시
situation.
조건에
So,
서로 차이가 있다고 하더라도
even if there is
각각의
some
라이센스
gap
계약의 특유한
in
판매
the
지역의 범위, 실시
royalty
수량,
rate and
시장 점유율,
conditions,
이용
we
형태,
need to
당사자
consider
사이의 관계 등의
the
여러
scope
요소들을
of region of
고려해볼 때
sales and the
일부
quantity
차이가
of
있다고 하더라도
implementation and
그와
market
같은
share.
차이가 관련 시장에서 경쟁을
So,
왜곡하거나 저해할
the
정도의
gaps
차이가 아닌 한
in the
차별적인
royalty
취급에
rate
해당한다고
and
보기는
royalty
어려울 것으로
conditions
생각됩니다.
could not be regarded
또한
as undermining the
손해배상과
competition in
관련된
the market.
쟁점으로는
And
표준 특허
also,
침해와 관련된 손해액 산정 시에
when
그
we
해당
calculate the
특허가
damages
표준으로
on the SCP
선정됨으로 인해서
infringement,
특허권의 가치가 증가한 부분까지 포함해야 되는지
whether we should include
아니면
the
이
added
부분의
value
가치를
of the
배제해야
patent
하는지 여부,
as the patent
그다음에
became a
실시료
standard.
과정, 즉 로열티
And
스태킹의 문제와
whether
관련하여서도 소위 하향식 접근법,
regarding royalty
탑다운
stacking,
어프로치라고 하는
whether
그런
we
방식에
select
의해서
top-down
손해액을 산정하는
approach
방식이
and
타당한지
calculate
등의
the
문제가
amount of
있습니다.
damages,
다만
these
아쉽게도
two
이에
are
관해서는
still
아직
under
한국 법원의
great
판례는 없고
discussion and
학자와 실무가들
disputes.
사이에서는
So far,
이를
we
인정하는
don't have
견해와
a special
부정하는
case
견해가 모두
precedent,
주장되고 있는
but in the
실정입니다.
academic sector, there
다음으로
are people who
무단 실시자,
agree,
즉
and
unwilling
also there are
license에
other
대해서
people who disagree with
손해배상액이
this
증액될 수 있느냐
opinion.
이런 가능성과 관련해서는
And whether we can have
2019년
enhanced
한국
damages
특허법이
for
증액 배상
unwilling
규정을
licensee.
신설하였습니다.
In
따라서
2019,
표준 특허권의
Korea
침해행위가
patent law created a threefold enhanced damages provision. So the threefold enhanced damages could be allowed. And if stakeholder who made friend commitment does not start negotiation on license contract with the implementer or refuses to sign the friend commitment, refuses to sign the license contract, that it could be regarded as the violation of friend commitment. And if such exercise of the patent right is considered as the abuse of patent right, then the damages could be limited, partially or entirely. Thank you for your answer. Next, Judge Granata from Belgium. Are you ready to answer?
답변 부탁드리겠습니다.
Yes, I'm ready, and I'll try to be very brief. For the reason also, I hope you understand me, for the reason that damages is something secondary in IP infringement cases. Mostly parties seem to settle. Secondly, it is important, as I already mentioned, that standard essential patent is patent, so the damages are calculated normally in the same way as a normal patent damages are calculated. In Belgium, actual damages should be proven. There exists no specific system to calculate IP damages other than the guidance possibly which is given by Europe in its directive, which you also will find in the questionnaire, a directive of April 29, 2004 on the enforcement of intellectual property rights. An important article within that directive is Article 13.1b, which actually gives the possibility to national legislators to higher the real royalty, sometimes to double it. Of course, there is some discussion whether this is punitive or not punitive, for example, in the case of an unwilling licensee. A final point is related to royalty stacking. Actually, in my opinion, there exists no consensus that royalty stacking is a real issue, and it's not known to me that in an actual case a party has submitted actual proof regarding such a claim. In the expert report of the European Commission, the ultimate solution to solve this risk, could it be proven, would be to use a patent pool system, which results in an aggregate royalty demand for all its members. And that's where I can end my answer. Thank you.
예. 그라나타 판사님 답변 감사합니다.
Thank you for your answer. In the case of Belgium,
특허 침해나 손해배상의 경우에도 일반
the
특허와
damages calculation for SAP is based on the calculation of damages for general IP. Judge Schaut from Germany.
Thank you very much. I can refer to what Judge Granata said to the situation in Belgium. I think in Germany it's the same. The patent infringement cases, they are about to get the injunction, not about to get damages. As you may know, as I have said before, it is rather easy to get an injunction in Germany, at least until now. But it is rather difficult to get damages because they have to be calculated, and there are so many ways to calculate them, and you have to prove them. And so that is why damages are not in the focus of patent infringement suits in Germany, but the injunction is. So that is why we don't have a very intensive discussion about how to calculate or evaluate damages in general for patent infringement, and especially calculating damages for SEP holders or SEP infringers. So I'm sorry that I cannot provide any specific German consideration on the evaluation of damages. We also know that there is the top-down approach, there are other approaches. We have no case law, especially not from our Supreme Court, which approach is the right one, or which approach should be applied. From my personal point of view, I would also say, as Judge Granata said, there should be no different system by calculating damages if we have SEPs and an implementer who is not a willing licensee. Thank you very much.
예, 샤와트 판사님 답변 감사합니다.
Thank you for
독일의
your
경우에는
answer. In the case
손해배상보다는
of
금지 명령
Germany,
쪽이 더 중점이
they
주어지고
focus
있다고
more
답변을
on the
하셨습니다.
injunction order rather than damages.
다음은 영국의 알렉산더 판사님 답변
Judge
준비되셨으면
Alexander
답변
from the
부탁드리겠습니다.
UK, would you answer the question?
Yes, thank you. There are considerable similarities with Germany and Belgium. First of all, in FRAND cases, there's no fundamental difference in the approach to valuation of patents. There is considerable experience from the pharmaceutical field and other areas where licenses have been determined by the courts, and the approach to evaluation is a similar one in principle. We have a very limited number of data points, though. Really, so far, there is only one case, the Unwired Planet case, that has done a full and comprehensive analysis. In that case, the focus was on comparables and quite a complicated assessment, not based on agreements for the specific portfolio in issue, but seeking to take results from a portfolio from which the portfolio was taken, which required quite complicated accountancy calculations as to the proportion of that portfolio which it represented. But the English courts also do top-down evaluation and to some extent do cross-checking from bottom up. There is no fixed approach, and in the case law, it is possible that different approaches may develop for different portfolios and different circumstances. So, for example, there may be portfolios where there is no real track record of licensing, so there are no comparables for that portfolio, or the comparables that are put forward may be unreliable. In those circumstances, different methods may need to be adopted. So we are in the middle of developing that. There's one further point just on comparables, which has emerged in the English case law on confidentiality. Even last week, our Court of Appeal was looking at a situation where it was said that the comparable agreements were confidential. Who could see them? And that is potentially an issue if one is doing that kind of evaluation. And we will see how that develops in the case law over the coming months.
예, 답변 감사합니다.
Thank you for your answer.
다음 마지막으로 미국의 벤시맹구 판사님 답변
Judge Bensimengo
준비되셨습니까?
from the U.S., are you ready to
예,
answer?
답변 부탁드리겠습니다.
Yes, thank you. So statutorily, the patent holder is always entitled to no less than a reasonable royalty for patent infringement, but of course you can always contract away your statutory rights. So the court would look first to the FRAND agreement under contract law to determine what the royalty should be. And that would consider the policy, the owner's commitment at issue, and then that can include then the value flowing to the standard by its adoption. And the court should analyze the specific terms of the policy to determine the scope and the meaning of the commitment, and that may require looking at foreign contract principles. But if the terms and the conditions are ambiguous, then the court's going to turn more likely than not to traditional patent law assessment. And at least the Federal Circuit here has said in that context, you don't look at any value flowing to the patent from the standards adoption. With regard to the stacking issue, the court has been very specific that simply alleging it, and I think that all the previous judges have said it's talked about, but there's not a lot of evidence of it, and you need to have more than just an abstract recitation of royalty stacking. You've got to provide some case-specific evidence, such as other licenses or royalty demands on the same standard, before you can present that, certainly to a jury, and probably even argue it to the judge. So trying to keep it on schedule, so that's a short summary. That's all I have to say.
예, 배시병구 판사님 답변 감사합니다.
Thank you very much for your answer. Next one.
이번 세션의 세 번째 소주제.
The third topic of the session.
지금 두 번째 소주제가 특허권자에 대한
The
특허권자의
second
구제수단이었다면
is
세 번째 소주제는
actually the third topic,
구제수단에
the means of remedies for implementers against SAP holders who breached FRAND.
특허권자가 프렌드 확약을 위반한 경우에
So if an SAP holder breaches its FRAND commitment, then what kind of civil remedies exist for the implementer? So if a patent holder declines to sign a license agreement with an implementer seeking to be a licensee without justifiable reason, or demands a royalty rate that is unreasonable or discriminatory, question of what kind of remedies are available to the implementers becomes an issue. Can SAP holder be liable for breach of contract in a civil proceeding if the SAP holder committed a breach of FRAND commitment? And secondly, if a willing licensee who was refused a license agreement files a civil lawsuit against the SAP holder, could the willing licensee request an order for specific performance forcing the SAP to enter into license agreement? Please answer the question in 2 minutes. Judge Alexander, would you answer the question?
This is a very difficult question. We have no case law on this because the issue in which FRAND has arisen has really only been in circumstances where an implementer has sought to invoke FRAND as a defense to proceedings for infringement and to obtain a license on appropriate terms. In principle, as a matter of English law, the issue of remedies under the contract obviously will depend on the precise terms of the contract, which may in turn depend on what the relevant law is that governs the obligation that has been entered into by the patent owner. So I don't think one can exclude that. The reason that I put the entry as difficult to prove loss in the slide is because ordinarily the English court would say, well, there is a remedy here that is readily invocable. If there is an infringed and valid patent, we, the court, can settle what the relevant terms are. And we haven't yet had a situation where a patentee has refused to enter into a license that the English court has said is in fact FRAND. I think that is not that likely to occur. One can imagine some situations in which it may, but the reason for a hesitant line in the entry is because it's an uncertain state of affairs.
알렉스턴 판사님 답변 감사합니다.
Thank you for your answer.
미국의 콘퍼런스 교수님.
Next, Professor Contreras from the U.S.
준비되셨으면 답변 부탁드리겠습니다.
Please answer this question.
Yes, thank you. Well, like Judge Alexander has explained in the UK, in the US there hasn't been an adjudicated judgment to specific performance in one of these cases yet, but it is theoretically available. And in fact, though I did not include this in my written response, there are 4 cases in the US in which specific performance has been addressed and discussed by courts in dicta. As early as 1999 in ESS Technologies versus PCTEL, the court allowed the parties' motion for, or the the party's claim for specific performance to survive a motion to dismiss, saying that there was a claim that was stated when the potential licensee sought specific performance by way of getting a FRAND license granted. The issue was discussed much more in Apple versus Motorola in 2012, where the district court did conclude that specific performance could be an appropriate remedy under the circumstances of the case, and she said, in fact, it may be the only appropriate remedy in the case. However, in that case, Apple said in court that it would not automatically accept the court's determination of a FRAND royalty rate, but that it would consider that royalty rate in deciding whether or not to take a license. As a result of that, the judge dismissed the case, saying that if she determined a FRAND rate, it would simply be an advisory opinion, which she was not willing to issue. And so the court declined to determine a FRAND rate and declined to grant specific performance to Apple because Apple would not commit to enter into the license. More recently, in 2019, this came up in two cases. In Continental versus Avanci, an automotive subsystem supplier sued for specific performance to obtain a SEP license when the SEP holder, Avanci, refused to grant such a license because it preferred to license the downstream automobile manufacturers, in particular Daimler, who was being sued in a German parallel case. This case, however, was dismissed in the US because it was brought primarily on antitrust grounds, which is the topic of the next question, and so the remedy stage was never reached. And finally, in TCL versus Ericsson, the district court held that specific performance was an available remedy under the declaratory judgment request of TCL. However, in this case, the question was also not finally adjudicated, as the district court's decision was reversed by the Federal Circuit on other grounds, jury trial grounds. It's been remanded back to the district court, and that case is in process. So we do not have any issued remedy of specific performance in one of these cases, although it has been discussed in at least 4 cases in the past.
예, 콘트라스 교수님 상세한 답변 감사드립니다. 다음은 중국의 추이 판사님 답변 준비되셨습니까? 중국의 추이 판사님, 예, 답변 부탁드리겠습니다.
There is few discussions and no case on this issue in China. I think it's difficult for implementers to seek civil remedies against SEP holder in our country. First, in tort law, China's tort law provides that any person who infringes on civil rights and interests shall assume the tort liability. But if a SEP holder breaches its FRAND commitment, he only causes pure economic loss, but he doesn't infringe a specific civil right or interest listed in the law. The requirements of the protection of pure economic loss is a very complex issue. And in contract law, as I mentioned in the first section, with current interpretation of FRAND, implementers can't seek civil remedies under contract law, but under the new civil code, the parties can agree that a third party may directly request the debtor to perform the debt to him, and if the debtor doesn't, the third party may request the debtor to assume the liability for breach of contract. Beyond that, the theory of contracting fault liability is kind of reasonable. I think it believes that FRAND impose pre-contract obligations. So we'll see if the opinions of scholars and the courts will change under the civil code. Thank you. That's all.
예, 추이 판사님 답변 감사합니다.
Thank you for your
다음은
answer.
일본의 쿠마가이 판사님
Next, Judge
답변
Kumagai from
준비되셨으면
Japan.
말씀해 주시기 바랍니다.
So, would you please answer the question?
Yes, yes. there's no relevant case or discussion directly dealing with this issue in Japan. So I think that this problem is very difficult, so that it depends on the legal nature of fund commitment. If the court finds that the legal nature of the disputed fund commitment is a contractual one, so that compensation for damages based on the contract or order to take a specific action based on the contract permissible. But if the court finds that this disputed fund commitment has not legal nature, just a voluntary one, so in my view, theoretically, the implementer can seek a compensation for damages based on tort. So I think that it is very difficult for implementer to seek to request a court to order take a specific action, yes, for stakeholder. So anyway, so I think that the further discussions and the considerations are necessary to give a clear-cut answer to this issue. Thank you.
예, 쿠마가이 판사님 답변 감사합니다.
Thank you very much for your
이 시제에
answer.
대해서
In Japan, they're still
심도 있게 논의된 바는
under.
없다는 취지로 말씀하셨습니다.
They still need to
다음
have
한국의
more
김기수
in-depth
판사님
discussion.
답변 부탁드리겠습니다.
일본의 쿠마가이 판사님께서 말씀하신
As
비슷한
Judge
상황인 것
Kumagai
같습니다.
said, there is a similar
한국에서도
case in
프렌드
Korea.
협약 위반에 대한
Civil remedies for
실질희망자의
willing
민사적
licensee
구제
for
수단이
breach of the
문제된
friend
사례는
commitment has not
없습니다.
yet been disputed in
제
Korean courts.
생각으로는 실시희망자가
Personally, I
특권자의
think
프렌드 합약 위반 행위에 대해 민사적 구제 수단을 행사할 수 있는지에 관한 문제는
In terms
결국
of whether
프렌드
a
합약의 법적
implementer
성격에
can
관한 논의로
file a lawsuit
귀착될
against
것
the breach
같습니다.
of the friend commitment can
프렌드
be
합약의 구체적인
interpreted
내용과
in
표준화 기구의 특허
depending on
정책
the
등에 비추어
content and
볼 때
details of the friend
프렌드 합약이
terms.
제3자를 위한 계약의 청약에 해당한다고
If it is an
해석될 수
offer to
있는
sell for
경우라면
a third party,
이런 경우라면
if
이론적으로는
that's the case,
제3자가 그와
theoretically,
같은
the
내용의
third party
계약의 이행을 구하거나 계약 위반에 따른 손해배상 책임을 묻는 것도
can
가능할
claim for
것으로
specific
보입니다.
performance of a license agreement,
반면에
and there's an
프렌드
agreement.
합약이
There is a problem
단순히
that
상실 협상
more
의무를 부과하는 정도의
patents are
의미로
declared
해석되는
to be
경우라면
essential than in fact are
프렌드
essential.
합약 자체로 실시희망자에게
policy
실시 계약의 이행을 청구할
Process
계약상
which
권리가
requires patent
발생한다고
owners to
보기는
declare
어렵고
SAPs in a timely
계약
manner when
위반에
a
따른
standard is
손해배상
being
책임을
prepared.
묻기도 어려울 것입니다.
So it will be very difficult
다만
to ask for damages.
특허권자가 성실
But
협상 의무에 위반해서
based
라이센스
on the
계약 협상을
negotiation
결렬시켰다면
obligation with negotiation in
계약
good
체결상의
faith,
과실 책임
and the SAP
또는
holders
민법상
are
불법 행위 책임이
negotiating the
성립할
contract terms
여지는 있다고
in good
생각합니다.
faith, there
감사합니다.
is a room for many
김기수
interpretation.
판사님 답변 감사합니다. 다음
Thank you for your
벨기에의
answer.
그라나타
Next,
판사님
Judge Granata
답변
from
준비되셨습니까?
Belgium. Would you answer the question?
예, 답변 부탁드리겠습니다.
Yes, I can actually refer to the answers which already were given and referring that there is no actual case law at hand. Maybe I could add, if it would be seen as a contractual breach of a contract, again, this issue of applicable law emerges, where we have to examine which law applies to the commitment of the SAP holder toward this implementer. It could also be considered possibly as a tort, and there it would be a breach in the pre-contractual obligation during the licensing process. Okay. Forcing the SAP to enter into a license agreement. On the other hand, he could ask damages, and these damages will be calculated as assessed as a loss of a chance. The questionnaire where I explain how this loss of a chance approach would be considered by a judge. Thank you.
예, 그라나타 판사님 답변 감사합니다.
Thank you for your answer.
통신장애가 있었습니다.
There have been technical
다음
glitches.
독일의 샤우트 판사님
Apologies.
답변
Judge
준비되셨습니까?
Schaut from Germany.
예,
Thank you very much. I think I can be brief because almost everything has already been said. The first question, can a SEP holder be liable for breach of contract? I would say yes. According to German law, can you get damages by the reason of torts? I'm not so sure. And I can refer to the other participants. We don't have this situation in Germany. We don't have these constellations in cases before our courts. So I cannot give you any decision where this question has already been decided. So my answer would be rather theoretical. But I said by contractual law, yes, there could be damages. And by law of torts, I'm not so sure this would have to be assessed in more detail according to the specific case. Also, a very interesting question, if a willing licensee, can he sue SEP holder to enter into a license agreement? I think we have such a case at the regional court in Düsseldorf, where Chinese companies use an SEP holder to enter into a license agreement. But as far as I know, I'm from regional court Munich, not from regional court Düsseldorf. I think this case has been stayed. So I can't give you any specific details on that, but I think it's also only one case in which this specific situation has been brought before a court, and we have no decision yet. That's all from me. Thank you very much.
예, 샤우트 판사님 답변 감사합니다.
Thank you, Judge
이
Shout,
주제에
for your
대해서는 아직
answer.
전 세계적으로
Regarding
열심히
this,
판례는 없는 것
across the
같고요.
world, it
다만
seems like there's
논의
no
중인
case law,
상태인 것
and
같습니다.
many countries are having discussion on this.
마지막으로
Last
이번 세션의
topic,
마지막 질문입니다.
last question.
표준 필수 특허권자가 프렌드 확약을 위반한 경우에
So if
실질자
the
측이 독점 규제법상
SEP
구제수단에
holder
관한
violated
것입니다.
the friend
최근
commitment,
표준 필수
will there be
특허의
remedy
라이센싱
for the
전략이
implementer in terms
독점
of the
규제법 위반에 해당하는지와
antitrust law?
관련된 법적 분쟁이
Legal disputes
세계
surrounding
곳곳에서
whether
벌어지고
licensing
있습니다.
strategies constitute
특허권의
violation
행사에
of
독점
antitrust
규제법을
laws are
적용할 수
taking
있는
place
범위가
around the world.
어디까지인지는
The extent to which
특허법과
antitrust law
독점
can be
규제법의 해석과
applied to
관련하여
the
매우
exercise
중요한
of a
문제입니다.
patent right is very
표준 필수
important.
특허권자의 프렌드
What
확약
is
위반과
the
독점 규제법
relationship
위반은
between a
어떠한
breach
관계가
of
있다고 볼 수
friend
있을까요?
commitment by SAP
프렌드
holder
확약 위반이
and a
어떠한
violation of
경우에 독점
antitrust
규제법
law?
위반이 될 수 있는지에 관한
And
자국의
could you
논의나
explain
사례가 있다면
if
소개해
there's
주시면
any case
감사하겠습니다.
that demonstrate where a
답변은
breach of friend
3분 이내로
commitment
해주시기
constitutes
바랍니다.
violation of
먼저
antitrust
영국의
law?
알렉산더
Please
판사님
answer the question in 3 minutes. Judge Alexander from the UK, would you start?
Thank you again. We have here also very limited data points. In the Unwired Planet case, the English court confirmed essentially the EU case law that it could be a violation of antitrust law, for example, to bring a claim without reasonable notice or prior consultation with the potential implementer. So in theory, that could constitute a violation of antitrust law. However, in practice, that is very unlikely to be an issue, because it's difficult to imagine circumstances in which an SEP holder won't have at least tried to obtain royalties from an implementer in one way or another, or at least put a licensing scheme up for potential acceptance. So while that provides a potential remedy, in practice, I am not convinced that it is a particularly practical one. And we have no case in the United Kingdom where an antitrust violation has been found. Second point is that, as the Unwired Planet case held, merely requesting terms that are in fact not FRAND, so making a proposal that is too high, even very much too high, in multiples too high, is not regarded a violation of antitrust law as such. And so there are real practical difficulties in obtaining a remedy based on antitrust law in the United Kingdom. I based my answers on the current state of play, which is that EU principles apply. We're, of course, facing the prospect of complete Brexit at the end of the year, when our antitrust laws may potentially change somewhat. And the position may, of course, change. I think in this area, they're unlikely to change very significantly.
예, 알렉산더 판사님 답변 감사합니다.
Thank you for your answer.
다음 미국의 콘트레라스 교수님
Professor
답변
Contreras from
준비되셨습니까?
the U.S., would you answer the
예,
question,
답변 부탁드리겠습니다.
please?
Yes, certainly. So at the moment, the pendulum in the U.S. has swung toward the side of this question that would suggest that there is not a significant antitrust liability associated with violating a FRAND commitment. The type of liability that one would consider here is liability for unilateral conduct by the SEP holder, what we call monopolization or attempted monopolization under Section 2 of the Sherman Act. There have been two recent cases in which those types of monopolization claims for FRAND violations were rejected by the courts. FTC versus Qualcomm, in which the Ninth Circuit Court of Appeals rejected antitrust claims made against Qualcomm for a variety of alleged violations of its FRAND commitments, violations that had been found by the lower court to constitute violations of the Sherman Act, but that was reversed by the Court of Appeals. Likewise, in Continental versus Avanci, which I mentioned, there the district court dismissed the case on the basis that it did not find that Avanti's refusal to license an automotive subsystem manufacturer under SEPS was an antitrust violation. The case was silent about the contractual violation, but the case was dismissed on the basis that it was not an antitrust violation. Compounding this, the U.S. Department of Justice has, over the past couple of years, expressed significant doubt about antitrust violations for such unilateral conduct based on breaches of FRAND commitments. That being said, there are two antitrust enforcement agencies in the United States, the Department of Justice and the Federal Trade Commission. The Federal Trade Commission has taken a different view, and the Federal Trade Commission operates under a different statute, the FTC Act in the United States, which has a section 5, which prohibits unfair methods of competition. And in the past, the FTC has prosecuted actions against potential violations of FRAND commitments under Section 5 of the FTC Act. Such cases were brought in N-Data, where a transferee of a patent failed to honor the original owner's FRAND commitment, and actions were brought against Google, Motorola, and Robert Bosch, those companies for seeking or threatening to seek injunctions against implementers of standards when they had made FRAND commitments. All of these cases were resolved through consent decrees between the FTC and the party, so none of these cases went to adjudication either. But clearly it was the FTC's position that these were violations of the FTC Act. And I would conclude by saying, of course, in other areas of standard setting, there have been numerous antitrust cases, mostly disclosure and patent ambush cases, the famous series of cases involving Rambus in the 90s and early 2000s, as well as Broadcom versus Qualcomm, and others have focused on compliance with the disclosure and other SDO rules, not on the particulars of the FRAND commitment. But with respect to the FRAND commitment, we really do not have any antitrust liability of any meaningful nature that has been found.
답변 감사합니다.
Thank you for your
다음은
answer.
중국의 수입 판사님.
Next, Judge Zhui from
답변
China.
준비되셨습니까? 예, 답변 부탁드리겠습니다.
Breach of friend may constitute a violation of antitrust law in our country, but it's only a factor to judge. Generally speaking, excessive loyalty, discriminatory loyalty, and bundling are reasons of violating antitrust law. A typical case is Huawei versus IDC. In this case, the court defined that every single SEP constitutes an independent relevant market. And because an ICP can't be replaced, so ICP holder is at dominant market position. But someone points that this judgment may be in the Sullivan fallacy, which means the definition of relevant market in this case is too narrow. The relationship between standards should be considered. In brief, in each individual antitrust lawsuit, we should define the relevant market, recognize the dominant position, and judge if the behaviors result in consequence of excluding or limiting competition. It cannot be directly presumed the abuse of dominant market position solely on the grounds of breach of friend or some relevant behaviors. Thank you. It's all.
예, 상세한 답변 감사합니다. 다음은
Thank you for
일본의
the
쿠마가이
answer.
판사님
Next, Judge
답변
Kumagai from
준비되셨습니까?
Japan.
The Japanese Antitrust Act provides that the exercise of IP right, including patent right, basically does not constitute a violation of Antitrust Act. However, recently, Japan Fair Trade Commission, JFTC, recognized that in some special cases, the exercise of IP rights may constitute a violation of Antitrust Act. And now currently, JFTC publishes a guideline for this. And because, as I mentioned earlier, the IP High Court adopted the so-called abuse of right approach in the Samsung Apple case for the brand-related cases. The relationship between the Antitrust Act and the brand commitment has not been consciously discussed in Japan. And but in relation to this issue, so we have a Blu-ray LLC case, which I mentioned in my written answer. In this Blu-ray LLC case, the panel of Tokyo District Court and JFTC both found the act of a stakeholder. So in this case, stakeholder notified the infringement by the defendant to the major retailers. And so such act constitutes the violation of Antitrust Act. And for further details, please refer to my answer. Yes. That's the end of my answer. Thank you.
예, 쿠마가이 판사님 상세한 답변 감사드립니다.
Thank you very much for your
한국의
answer.
김기수 판사님 답변
Judge Kim Gi-soo.
부탁드리겠습니다.
감사합니다.
Thank you very much.
기술 혁신을 통한 소비자 후생의 증가 및
The Patent Act and the Fair Trade Act serve the same
특허법과
purpose in that
공정거래법이
they
그
promote
목적을 같이
consumer
합니다.
welfare and dynamic market
따라서 그
environment
목적에
through
반하지
technical
않는 한
innovations,
특허권의 행사는
technological
공정거래법의
innovations.
위반이 되지
Therefore, the
않습니다.
fair exercise of
한국
patent rights does not
공정거래법
violate
59조에는
the Fair Trade
특허권의
Act
정당한
unless it
행사라고
goes against the
인정되는 행위에 대해서는
purpose. According
공정거래법이
to Article
적용되지 않는다고
59
명시적으로
of the Fair
규정하고
Trade
있습니다.
Act, you can see the Korean
한편
providers.
왜
Korea
항상
provides that the
특허권의
Fair
행사로
Trade Act
보이더라도
does not apply
그
to the
실질이 특허 제도의
acts
취지를
determined to be
벗어나
legitimate exercise of the
제도의
rights under the
본질적
Copyright
목적에 반하는
Act.
경우에는
Meanwhile, acts
특허권
that appear
행사라는
to be
유만으로
used for
공정거래법의 적용
exercise of patent
범위에서
rights but are
제외시켜서는 안
against the
됩니다.
purpose of the Patent Act and restrict
특허권자가
competition in
브랜드 허격을
substance should not
위반하여
be exempt from
특허권을
the Fair Trade
행사했다고
Act
해서
merely
항상
because
그
they
행위가
happen to be
특허 제도의
used or
취지를
exercise
벗어나
of
제도의 본질적
patent
목적에
rights.
반하는 것이라고
A breach of
단정할
a
수는
friend
없습니다.
commitment is clearly an act that may be
그러나
suspected as going
특허권자의
against the
브랜드
purpose
합약
of the
위반
Patent
행위의
Act.
모습과
However, it should
그
not be
경쟁
deemed
제한적
that the
효과
SAP
그리고
holders
경쟁 제한
exercise
의도
of
등을 구체적으로
patent rights in
살펴보아서
breach of its friend
그것이
commitment is
특허권의
always
정당한
against the
행사라고 볼
purpose
수
of the Patent
없다면
Act.
공정거래법이 적용되는 것도 가능합니다.
So a clear look
표준
into
필수 특허권자의
the
브랜드
acts
허격
of
위반
restrict
행위
effect
중
on
공정거래법 위반 여부가
competition and the
문제되는
intent to
행위로는
restrict competition is it
특허권자의
necessary to
금지
determine
청구,
whether to apply the
차별적
Fair
실시료에
Trade
따른
Act
실시허락,
among the acts in breach of friend
불합리한 실시허락 조건 부여,
commitments of an SCP holder
실시허락의
or
거절
the
등이
SCP
논의되고
holder
있습니다.
claiming for an injunction licensing
구체적으로
with discriminatory
표준 필수
royalties,
특허권자의 금지 청구는
attaching
삼성 애플 사건에서
unreasonable
차별적
conditions for
실시로,
licensing and
불합리한 실시허락,
refusing license.
실시허락의 거절 등은
We
퀄컴
can see an
사건에서
example
문제가 되었던
in
쟁점입니다.
a patent litigation between the
그중에서도
Samsung and Apple
특허권자가
and
최종
another
판매
litigation
제품
between
단계에서의
Qualcomm.
특허 소진을 회피하여 이익을 극대화하기 위해서
In order to maximize benefits
부품
by
제조사와
adjusting
라이센스 계약을
a
체결하지
patent
않고
without
대신에 부품
entering into
제조사에 대해
another
특허 침해 소송을 제기하지 않겠다는
another
구제소
contract or
허용을 한
agreement.
전략이
There was a
공정거래법 위반에
friend
해당하는지는
commitment
매우
between the
흥미로운
parties, and it
쟁점입니다.
was a very interesting case for
서울
the
고등법원은
perspective of
특허
fair
소진
trade.
회피를 위해 모뎀 칩셋 제조사의 라이센스를 거절한 퀄컴의 행위가
The Seoul
시장 지배적
District
지위의
Court
남용 행위
said
중에서
the Qualcomm's Act
정상적인 거래 가능에 비추어 타당성
in
없는
terms
조건을
of
제시하여 다른
normal
사업자의 활동을
practices
부당하게 방해한 행위라고
as
보았습니다.
an intervention or
현재 위 사건은
interruption of
선고되어
other businesses.
대법원에 계류
And this
중입니다.
case was brought
감사합니다.
to the Supreme Court.
김기수 판사님의 상세한 답변 감사합니다.
Thank you very much for your answer.
벨기에
Next,
그라나타 판사님
Judge Granada
답변
from Belgium.
준비되셨습니까?
Would you answer the question?
Yes, thank you. Of course, central in the discussion is the holding of a dominant position, where one could argue that a SAP holder should as such be considered dominant due to the essentiality of the patent, and following the lack of alternative technology, situation may occur though that the SAP holder holds no dominant position. This assessment, as for most cases to be dealt with before a court, depends on the facts of the case, where technology, the underlying technology in which the discussion is situated may have some importance. And I refer specifically to the opinion of the Advocate General Wathelet in the already mentioned case Huawei versus ZTE. Examples of factual situations which could give rise to a higher barrier compared to the non-discriminatory evaluation could be, for example, a royalty rate higher to firms competing with the own standard compliant products. As a personal note, I could add that where it would be attractive to make use of the competition law principles to assess the non-discriminatory prong of the friend commitment, we should take into account that where discriminatory licensing terms and conditions are ipso facto in violation of the non-discriminatory commitment made by the SAP holder, the FR, fair and reasonable, in combination with the non-discriminatory prong, could hold licensing terms and conditions impermissible, while they could be allowable under antitrust law. But as mentioned, there is no actual case law where this has actually been addressed. And that's my answer to this question.
예, 그라나타 판사님 답변 감사합니다.
Thank you very much for your answer.
독일의 샤우트 판사님
Next, Judge Schaut
답변
from
부탁드리겠습니다.
Germany.
Thank you very much. Yes, also in Germany we have no specific case law on this. I think there are two questions. So the first question will be the FRAND commitment, which we discussed earlier, whether it's declaratory or whether it has some binding effect due to a contractual law. And there's the antitrust theory. So in Germany, we usually, as I said before, we solve the cases if we have a SEP holder and it is proven that his patent is standard essential. We apply the EU antitrust law, and then also, of course, then the also already mentioned decision of the EU court, Huawei versus ZTE. And if the SEP holder is not complying with its obligations to FRAND, not giving a FRAND license, offering a FRAND license to the implementer, he will not be allowed to claim an injunction or a revocation of the products of the infringer. I think so. This is maybe the link between front commitment or friendly friendly behavior of the SEP holder and the antitrust law. Thank you very much.
예, 답변 감사합니다. 이것으로써
Thank you
준비된
for your
질문은 모두
answer.
마쳤습니다.
This will be all for our Q&As.
오늘 혹시 발표자들 중에서 다른 발표자에게 질문 사항이 있으시거나 오늘
Among
말씀하신 내용
panelists and
중에서
speakers,
추가하실
would you
부분이
like to
있으신
ask
분은
any
말씀해
question
주시기
to the other
바랍니다.
panel, or if
먼저
you would like to add anything,
영국의
please
알렉산더
make
판사님
comments. Judge Alexander, would you
있으신가요?
like to add something, or do you have question or anything would you like to say?
No, just to thank the other speakers for extremely clear presentations and to apologize for not being able to provide clearer guidance from the English and the United Kingdom front on some of these very difficult issues.
예, 감사합니다. 다음
Thank you.
미국의 벤시벤코 판사님
Judge Bensivenko,
질문 사항 있으신가요?
do you have any questions?
I don't have any questions. I'd like to join the previous speaker in thanking you as well for inviting me to participate. This is a very rapidly changing and evolving area, and I think that what I heard was a lot of consistency from across the countries about where the concerns are and the approach, and while the issues keep coming to the front, they're not getting battled out in court a lot. They seem to be resolving. If people don't get what they want right away, they go off and arbitrate or settle, which doesn't help. I don't want to decide them myself, but necessarily we don't get things to go up to the appellate courts to get final guidance if parties are going to do it on their own. But if that's the way they want to do it, that's fine too. Anyway, thank you all for inviting me. I enjoyed being part of the program.
예, 감사합니다. 다음
Thank
미국의
you.
콘트레라스 교수님
Professor
질문 사항
Contreras from
있으신가요?
the U.S., do you have any questions?
No questions, but like the others, I would just express, I actually learned very much from this presentation, and I have really come to appreciate how there are really more questions than answers all around the world on these topics. So this is a topic that will continue to provide fruitful discussion for many years and many conferences to come. So thank you very much for inviting me to participate.
예, 감사합니다. 다음
Thank you.
중국의 추이 판사님
Judge Chui from
질문
China,
사항 있으십니까?
do you have questions?
No questions, and I would like to clarify, I'm from the IP Court of the China Supreme People's Court, which was established on January 1st last year. And we take charge all cases on appeal nationwide. And as a member of this new institution, again, I feel very honored to be invited to attend to this conference. Thank you very much.
예, 감사합니다. 다음 벨기에의
Thank you.
그라나타 판사님
Judge Granada
혹시
from
질문 사항
Belgium,
있으십니까?
do you have questions? Judge Granada, do you have questions?
No, I also wish to thank you.
예, 감사합니다.
Thank you.
일본의 쿠마가이 판사님
Judge Kumagai from Japan,
혹시 질문 사항 있으십니까?
do you have any questions?
No, thank you. Yes, first of all, thank you very much for my Korean friends for organizing such a great event. So I'm really impressed to know the latest developments of the issues surrounding brand and SEP. So recently, information technology and is changing very rapidly. now we are facing a very common problem all over the world. It is a very great chance for me to share the precious knowledge with the other panelists. Thank you.
예, 감사합니다.
Thank you.
독일의 샤우트 판사님, 질문사항
Judge Shout
있으십니까?
from Germany, do you have questions?
Actually, I have a lot of questions, but due to the fact that it's 4 o'clock in the morning here in Germany, and that I will be requested in office in about 4 hours, I will refrain from posing or from questioning all my questions now. And it remains to me also to thank you very much for your for giving me the possibility to take part of this great panel, and I hope we can continue these fruitful discussions in the future. Thank you very much.
예, 감사합니다. 시간이 거의 다
Thank
됐습니다.
you.
혹시 플로어에서
Time's
질문하실 분이
almost up,
있으신가요?
but does anyone from the floor have a question?
그러면
If not,
이번 세션을 모두 마치도록
we'd
하겠습니다.
like to
이번 세션
conclude the
발표자분들과
session.
현장 및 온라인으로
I
이번
would like
세션에
to thank
참여해주신
all
모든
the
분께
panels and
깊이
speakers
감사드립니다.
and participants for the
발표자분들께
session.
감사의 박수를 드리는 것으로 본
Please
세션을 모두
give
마치도록
the
하겠습니다.
presenters and
감사합니다.
speakers a big round of applause. Thank you.
감사합니다. 이것으로
Thank you
다섯
very
번째
much.
세션을 모두
This will be
마치겠습니다.
all for the
어려운
fifth
주제를
session.
이끌어주신
Thank you
연사분들과
very
김동규
much,
고등법원
speakers,
판사님께 다시 한번
panels,
큰
and the
박수
moderator.
부탁드립니다.
Please give them another round of applause.